Every divorce that comes to my office is different, but about 80% of the questions people ask are very much the same. So in this video, I'm going to run through the 12 most common questions we've been asked in just the last few months. I'm Vanessa Vasquez, founder of the Vasquez Lara Law Group, where we make lives better in and out of family court. Now, realistically, I've been practicing for over 20 years, and people are still amazed when they ask me the craziest question you've probably ever heard, and I'm not surprised or fazed. That's because there's very little that surprises me anymore. However, most of the questions we get are pretty standard. They're the questions a lot of people ask because they're the things most of us really care about. Now, obviously, this list is not exhaustive, and it's not going to be specific to your particular case. My goal here is to address these questions so you at least have an understanding of how the system works. That should help you tailor your questions for your discovery call and get the absolute most out of it. And because it's a long list, I'm not going to fully answer each question. It's more of an overview, but where I have other videos that do go more in depth about a particular topic, I'll provide the link. We'll also have the timestamps in the description so you can jump to the questions that are the most important to you and skip the ones that might not be relevant to your situation. So let's get started. Number 1, should I get divorced? This isn't the most commonly asked, but it is the most important. But it's not one that I can really answer for you. We're attorneys, not counselors or spiritual advisors. We can give you legal advice about what your rights are, what you're entitled to, and what potential outcomes might be. We can even tell you if it's in your best legal or financial interest to get divorced. But I know there's a lot more that goes into the decision. We can make sure you make a well-informed decision, but we can't make the decision for you. Number 2, do I actually need a lawyer? The short answer here is no. You can absolutely file everything in court, appear before the judge, and make all your motions yourself. And if you both agree on everything and you're not concerned about getting less than you're entitled to, filing pro se, which is the legal term for a DIY, may work out for you. But the real question isn't, do I need a lawyer? It's, what risk am I taking if I don't have one? The law can get very complex, procedures can get very specific, and arguments have to be very relevant to what judges can consider and what they can't. I've seen people lose time with their kids, give up hundreds of thousands of dollars they were entitled to, and have their cases thrown out and have to start all over because of simple mistakes an experienced family lawyer would have avoided. To use an analogy, you could technically install all the outlets and light fixtures in your house, but what are you putting at risk by not having an experienced electrician handle that for you? Number 3, what type of divorce do I actually have? There are basically 2 types of divorce in Florida, uncontested or contested. If you both agree on everything or at least trust each other to be fully transparent or fairly negotiate outside of a courtroom, then you can do uncontested or a special version of uncontested called a collaborative divorce. It basically means everything is decided before you file for divorce, and we give the court your petition to dissolve your marriage and the marriage settlement agreement all at the same time. However, if you don't agree on something, could be time sharing with the kids, alimony, the division of assets and debts, or any other issue, you may have to go the contested route. This is traditional litigation where your attorneys file the petition and then the court compels each side for full financial disclosure, negotiation, mediation, and sometimes even a trial. Basically, ask yourself if you need a judge to decide on something or force your spouse to comply. If so, then your case is contested. Number 4, what should I do before filing anything? Honestly, probably less than you think. You should start gathering information and making sure you have access to as many of your personal and financial records as possible. You also need to start planning for life during and after your divorce. Where are you going to live? What's your budget going to look like? How is your routine and your kids' routine going to change? The more prepared you are, the better. What you shouldn't do is just as important, and the big one here is try to move money or change your household contributions. As lawyers, we're pretty good about tracking down missing money, and trust me, that's not a good look to the court. And the court is going to expect that you maintain your normal contributions to the household until the divorce is finalized. Even if you move out, stop paying bills now and it could turn into a huge bill and headache later. Number 5, does it matter who files first or when we file? There are some advantages to filing first, but they're not necessarily big deciders in the case. The main advantage is preparation time. If your spouse files first, we'll only have 20 days to review their petition and request, then prepare your response and your counter petition. Now, if you're well prepared and just waiting, it might be a non-issue. issue, and just because you hire us doesn't mean we have to file right away. If we see some reason to wait for the other party to file first, we can be ready. Where people get stressed is when they wait until they're served papers to hire us, and then they have to drop everything to gather everything that we need. The only other advantage to filing first is getting to decide where the case will be heard. If you live in different counties, the divorce could be filed in either one. So if you want it closer to you, best to file first. Now, as for when to file, the only general advantage to that is the court schedule. Peak times for divorce filings are in the first 3 months of the year, and then late August through September after the kids go back to school. If there's a lot of cases on the court docket, your case could take longer. Not always convenient to file in the summer, and it can seem a little weird to file in the holidays. But if speed is something that's important to you, it's definitely something to consider. Number 6, how long does a divorce usually take? I've done a whole deep dive video on this, so I'll just hit the basics here. The absolute shortest it's going to take, if you agree on everything, is about 4 to 6 weeks. That's because there's a 20-day mandatory waiting period, and then it takes about another 20 to 30 days to be finalized. Now, if you're going uncontested or collaborative, it really just depends on how fast everyone gets the information in and how much we have to negotiate, but that may be another 1 to 3 months. And if you're going contested, that's where things get really tricky. The guidelines say it should take 6 months, and we're seeing judges really start to enforce this, but it's not for certain. And if you have a lot of disagreements, have to have a lot of hearings, and ultimately go to trial, I've seen divorces take as long as 2 or more years. Number 7, how much does divorce cost, and why does it vary so much? Let me answer both of those questions with one of my own. How much do you want to fight about? There are such things as flat fee divorces, but those are really where there is nothing to fight about. No kids, no assets, no debts, no alimony. We can handle all the paperwork and make sure everything is done for you for a few $1,000s. I can't tell you specifically in this video because there are a few variables we have to check. But the reality is the vast majority of divorces do not fit that category because there's at least one thing to fight about. For a lot of divorces, to get the process started, you're going to be in the neighborhood of $4,000 to $6,000. And then where the costs go from there are completely dependent on how much you and your spouse disagree and how much time you're requiring from your attorney. The key thing to remember is that everything your attorney does for you, every email, phone call, in-person meeting, and court appearance is going to be billed by 6-minute increments. If your situation requires a lot of work, it's going to cost a lot. At our firm, we're not going to try and create conflict where there isn't any, but we are going to make sure you always know your rights. I've made other videos on costs, how to keep costs down, and how billing at our firm works, so make sure you check the links to those too. Number 8, do I have to go to court? Maybe. It really just depends on the particulars of your case. If your case is contested, then absolutely you have to go to court at least once and very likely multiple times. Fortunately, since the pandemic, a lot of our hearings and depositions can be done by Zoom, but there are some judges who are moving things back to in-person. Now, if your case is uncontested, there is a chance you'll have to go to court, but there are a lot of cases where all you have to do is sign the paperwork and we can make all the appearances on your behalf. Number 9, what happens with the kids? This is another one I've done a lot of videos on, so make sure you check those out. Here's a few key things you should know. There is no custody in Florida. We split it up into time sharing and parental responsibility. Time sharing is about how many nights in a year the kids are with you and when are the kids with you. Parental responsibility is about who gets to make which decisions on things like school, religion, extracurriculars, and medical care. Those can be split in a lot of different ways, but the default is for those decisions to be made together. You really need to decide what are some of the most important things to you, though, if you're asking the court to order those to be split. When it comes to time sharing, the starting point for decisions is 50-50. That means that unless we can give the judge a compelling reason why it's in the child's best interest to be with you more than the other parent, they have to divide the time equally. That list of reasons includes things like school routines, medical care, and safety. It does not include things like traditions, societal expectations, and in a lot of cases, it doesn't include the preference of your child. Number 10, what if we don't have a parenting plan yet? Most divorces don't start with a parenting plan. And even if you're wanting to go the uncontested route, it's okay. One of our most common jobs is helping you decide on the best parenting plan for you. We've seen just about every parenting plan you can think of, and a lot you've never even think of. Who gets holidays? When should handoffs be? And where? We've seen them all. You don't know what you don't know. So let us help guide you through the options. Number 11, on what happens to our money and assets. Definitely go watch my deep dive video on the division of assets and debts. But I'll give you a quick synopsis here in 3 basic steps. We figure out what is marital and what is non-marital. Basically, the value of anything you own before the marriage is yours. Unless you have a prenup or postnup, the value of anything you acquired after you were married, and here's the big one that throws people, the appreciation on anything since you've been married is considered a marital asset. It doesn't matter whose name is on the account or the title. The only thing that matters is when it was acquired or if it was owned during the marriage. We put all your marital assets into one big pot. Real estate, retirement accounts, bank accounts, sometimes even your cars, jewelry, and power tools, and get the value. Then we take all of your marital debts, your mortgages, your credit cards, maybe even your student loans, and then we take the value of the debt away from those assets. Once we have your marital net worth, we split it in half, and that's the starting point. Ideally, you walk away from the marriage with that value and assets. Where it gets tricky is moving around the assets and debts to get it to that number. And sometimes that means we have to sell assets to split the value between you. Now, there's a lot of other particulars with this, so definitely go watch my other videos. Just know that what the court considers fair isn't always what you think is fair. Number 12, what if we agree now but disagree later? I love this question because it highlights such an important point. It is much easier to get things right the first time than it is to change them later. I can't tell you how many divorces I've seen where people agreed to something that they didn't really understand and couldn't possibly follow through with. People have agreed to give up time sharing they didn't need to, pay expenses they didn't need to, and give up assets they didn't need to. And the hard part is that some things like asset division are impossible to reverse once a divorce is finalized. You can't just take the house back or get more of the retirement. Things like time sharing with the kids can be modified, but not just because. There are legal standards that have to be met and significant changes that have to happen in yours or your ex's situation for a judge to even consider it. And the reasons for changing child support or alimony are even narrower. Now, if both you and your ex agree, lots of things are possible. But if you think a judge is going to make your ex change what you already settled on in the divorce, just know it's a hard battle. And that's why you need a dedicated, experienced family lawyer like one from my team to guide you through the process, look out for your best interests, and help you make the best possible decision you can the first time. So those were the 12 most common questions we've heard at the firm in the last few months. Chances are at least some of them were applicable to you. And some of these may have totally answered your question and put your mind at ease. But I also know that you might have even more questions. My hope is that they have given you some clarity. So when you get to your discovery call or a consultation with my team, your questions can be as specific to your unique situation as possible. And even more so, I hope we can help you make the decision, not on whether you should get divorced or not, but on whether we're the right firm to be your guide through the process. I'm Vanessa Vasquez, founder of the Vasquez Zara Law Group, where we make lives better in and out of family court.